Hello, everybody, and welcome to the ACG event on consumer data privacy. My name is Ashley Tarver, and I work with the ACG. I'm on the board of directors and also co-host their CTO Innovation Circle. And today we're hosting this event focused around consumer data privacy. We do have upcoming events that will be scheduled throughout the year. So the ACG is actually an organization of about 58 chapters across the United States. And we focus, the whole ACG, the Association of Corporate Growth, focuses on delivering programs like today's programs to help educate local businesses and also create camaraderie at the local level at each of the chapter locations. Our next event is scheduled for Thursday, January the 19th. 5 o'clock Pacific Coast time, and it's going to be focused on the capital outlook, where with all the conversation recently around pending recessionary issues, we thought it would be very smart to pull together a panel to talk about those opportunities or those issues, and that's going to be coming up on January the 19th. So thanks for participating here. And as we have more people join, let me make a quick introduction. We have a group of panelists today that cover a broad range of backgrounds, but our host is Katerina, and she comes from the IAPP, which is the International Association of Privacy Professionals. She's got an excellent background across privacy overall. She's a primary researcher for the IAPP, and she brings a wealth of expertise and knowledge in this industry. So she's going to be the host and the panel coordinator for today's conversation. So Katerina, I'll turn it over to you. You can make a short introduction of the panelists and we can just jump right into the topic. Thank you.
Thank you. So hello, everyone from my side. Thank you for your kind introduction, Ashley. It is a great pleasure that I will be your moderator today for this distinguished panel, and I'm happy to right away introduce our speakers. So Lisa is the Chief Security Advisor at Microsoft, focusing on business development, strategy, and ventures relevant to security, compliance, and identity. Thank you, Lisa, for jumping in so spontaneously. We are very happy to have you. Jasmine, you are the CEO of mBlue Labs, a fast-growing bioscience company, but also look back on an extensive career in tech, including leadership positions at Sprint, Cisco Systems, and NCR. Thanks for being here with us today. Ellen, you're chairing the Global Data Privacy, Cybersecurity, and Digital Assets practice at Squire Patent Box, and we're looking forward to you highlighting the priorities companies should set for privacy compliance. Thank you for joining. And last but not least, Brad, you have not only been the co-chair of the CTO Innovation Circle for ACG Silicon Valley, so many people listening in are probably familiar with you, but you are the CEO and co-founder of Privacy Care, a consumer data privacy service that can manage and track consumer privacy requests. So I would like to thank all of you for contributing to the discussion today, and also thank everyone listening in for allocating time from your busy schedules to join us. So speaking of busy schedules and jumping right in, privacy never sleeps, and 2023 does not only start with the California Privacy Rights Act, the CPRA, and the Virginia Consumer Data Protection Act having become effective on January 1st, but we have Colorado and Connecticut's Data Privacy Acts becoming effective on July 1st and Utah's on December 31st. So not only that, we have also seen the California Attorney General announcing the first public enforcement action under the California Consumer Privacy Act in August last year, and the California Privacy Protection Agency starting enforcement of the California Privacy Rights Act. So with an alphabet soup of terms and laws here. The enforcement of the CPRA, which is an amendment to the already existing CCPA and is adding new privacy protections on July of this year. And of course, we have the FTC, which will remain very active in 2023. And I'm not going to go down the rabbit hole that 17 states have already started their legislative sessions this year, and several states have already introduced new privacy bills. And President Biden, I think that I just want to mention this, has posted or published an open ad piece in the Wall Street Journal just yesterday, emphasizing the importance of a potential federal privacy law. So in other words, it's just a lot. Alphabet soup that can be confusing for everyone. And this is why the IPP is also very happy to help with tracking new developments. And I will post some resources in the chat later that you can look up on our website. So thank you. So let's dive into our topic right away. And if you, the audience, have questions, bless you.
Thank you.
Put them in the comments in the chat, please, and we will try to address them in the second half of our panel discussion, or if the panelists want to take them right away, just let me know, please. So I would like to start with a short round going around the room and first ask all of you panelists to please share very briefly what's your interest in consumer data privacy and which perspective will you bring to the discussion. And if I may start with Lisa, please.
Sure. So I've been interested in privacy for a long time, both as a consumer and as a security professional. Those security and privacy work together very closely. And Microsoft being a service provider in this context of the conversation that we're having today, there's a lot of effort with Microsoft. And so we have a lot of very smart people at Microsoft who are busy working on this, including our chief privacy officer. So it's a big area of interest and focus for us.
Yes, we work so closely with Julie Brill at IPP, and we're very happy and honored to have her involved so much in the community. Jasmine, what's your take on consumer data privacy? Is it overwhelming, or what's your initial reaction if you hear those terms?
We are a consumer brand. Blue Lean is actually our clinical skincare line, and we're 80% consumer direct. So handling consumer data is an absolute, a very, very important area for us to focus on. I mean, nothing damages your brand more than customer sentiment that goes negative. So for us, it's critically important that we understand what's expected of us as a brand owner, as well as how we leverage still our marketing dollars in the best way to continue to market effectively to prospective customers.
Right, there were so many things to unpack. So thank you so much. Also, this notion of consumer trust that goes well beyond privacy, but privacy is the main part. So Ellen, I mean, I assume to know what you will bring to this discussion, but may I ask you to also introduce yourself or your perspective?
Sure. So I lead Square Patent Bug's global data practice. We have 80 lawyers in 11 countries advising clients on how to comply and also how to commercialize their data, comply with laws and commercialize their data. I'm in California, so I can bring a uniquely California perspective, but more and more with Europe, Middle East, Africa, APAC, and even South America, rolling out laws and enforcing them. A lot of what we're doing is trying to create a global program for clients rather than a patchwork. And we've seen that in preparing for these 5 state laws, 4 new ones and an updated California one, maybe 6 if you consider Nevada's little light touch on do not sell. Clients for the most part doing the same thing here, which is I'm not going to have 5 different consumer rights request flows depending upon the state. And to Jasmine's point, and a lot of clients are saying, and I'm not going to tell someone in Alabama that they can't have access to their data or exercise these rights. On the other hand, there are business imperatives that have to be weighed, and particularly with digital advertising, the impact of do not sell, share, target is very real for a lot of digital advertising driven e-commerce companies, such that they are going to limit the opt-out rights based on IP address geofiltering. So there's no one size fits all. It's really about working with the Jasmines of the world to figure out what is their business, what are their data practices, what is their ethos, what is their brand, and coming up with a tailored solution for each client.
Perfect. Thanks so much. I will absolutely pick your brain later for prioritizing things and so on. And Brad, thanks for being here again. Like Privacy Care is having really a very useful service. What's your interest in consumer data privacy, maybe personally or company-wise?
Well, thank you so much for the introduction, and thank you all for joining today. I think our primary and core focus is really on the consumers themselves, so all of us on the call, and our day-to-day interaction with data. And now that we have access to be able to, pull our data back or control our own data, and from a business perspective, giving people the access and doing it in a simple and easy way. And you talk about Jasmine's business and just making it as easy as possible. And she and both Alan touched on some key points: branding and consumer loyalty. So compliance is important, of course, but if you don't comply and your business starts to suffer as a result, that's problematic. So we've come up with a basic and an easy solution to be able to track requests and be able to adhere to them so it doesn't become a nightmare.
I see. That's great. Thank you. So maybe let's dive in by Jasmine being our, we're all gonna coach Jasmine. That's what I understood. Like you're like the very good example, but like a real life example of being confronted with so many new privacy laws or privacy requirements. How, and that's not your core profession like mine, for example. So I mean, it must be overwhelming. I could imagine. So how do you educate yourself on those new laws, and how do you, what have you learned to respond appropriately? How do you go about that?
Yeah, so we launched our brand in 2019, literally a year before this really became a much more widely discussed topic. And at the time, we looked at different platforms to build ourselves on. We opted to go with Shopify, which was on the advice of our marketing head. Having worked in high tech myself before, I was keen to just build an enterprise class system ourselves and move ahead. But I'm really glad I listened because Shopify does have a very scalable solution for customer security. And it is, as a result, been much easier for us to be compliant than had we built our own platform and managed it ourselves. So that's, for a new brand, a consideration, I think, as we look at new businesses, really pick apart the security piece. For us, we were more concerned about transactional security, credit card security, for example, in 2019. But now it's a completely different ballgame, right? It's all the data that pertains to a customer that needs to be protected. So it is looking to our experts externally to help guide us and say, well, you're still compliant, and challenge us. So we do have good business mentors. We're still, from startup now to small business, who make us take a look at our process and procedures. And again, we feel pretty confident that we have our arms around it today.
That's really great. If you can start with like privacy in mind right away. Brad, how do you experience that? What is your experience in helping companies to comply with the new laws I've listed and the ones we already had, especially when you maybe already have a tech stack? So can you tell us about the implications of these new state laws, and maybe also for whom are they relevant? Does it matter only when you operate in those states, or does it go beyond that?
So great question. And, two types of systems, right? So she just started a new business. So she can start with net new systems. So that's a ground buildup. Many companies or several companies have been in business for a while. So those are legacy style systems. So then they need to go back, and it really comes down to looking at where is your data, but what are your data policies? And some companies thought about that when they began. Most companies just began and they didn't really think about it too much. And then time goes by and people change jobs, and maybe they have access and maybe they don't. But then when these laws come up, it requires everyone to become a steward of their data. And so as a result, they now need to have these policies. And that's really a key part of this. And then obviously as a retailer or somebody who's customer facing in any of these businesses, the key again comes back to the branding and customer loyalty to make sure you're doing the right thing. So tracking, our perspective is really the beginning. And it's really about being human about it and being able to communicate with your customers and let them know that you're there. And when they make requests, you can respond and let them know you're tracking and you're going to adhere to what they need. and make sure that they feel good about your brand. We all shop in different retailers, and you might feel an affinity to a particular retailer. If that retailer gets hacked or breached in some way, you might give them an opportunity and say, okay, I'll give you one chance. But if it continues to happen and your data has been breached, you're not going to feel really good about it. So they have to really take, a level of care, if you will, with you and with your data, because it's personal to you. So I think it's really critically important that communication lines be open. Does that make sense?
Yeah, totally. I mean, it reminds me of this term or notion, privacy as a business enabler. So it's not only like a burden for the business, it can also be turned into something to strengthen your brand, to increase consumer trust. So that's what I heard. Ellen, what are the implications of these new privacy laws or the existing ones from your perspective? So from your perspective, could you give us an overview of what priorities companies should set for the 5 state laws entering into force this year? And I think that's also what you already mentioned at the beginning. Is there a way to comply with all of them? Maybe if you set a very high standard, how would you go about advising companies, especially like maybe smaller, medium-sized companies, to go about this challenge?
Yeah, so I think it's interesting the journey that Jasmine's taken, because a lot of startups would say, we're not going to hit the thresholds for a couple years. So these laws don't apply to us. We're not going to worry about it. But then you miss the opportunity to build privacy by design, to build your information systems and your information governance program in a way that prepares you for when you do hit the thresholds. And nobody's starting a business if they don't expect to be successful and they're looking for an exit. I've seen so many acquisitions go south because data-driven businesses were not built around the proper compliance, and the buyer didn't want to buy the liabilities, right? So there are pretty high thresholds, particularly outside of California, for the other states. That is not some of the other countries, for the applicability, but to build a business around knowing that you're eventually going to be subject to these laws, I think is prudent. Then the question becomes, are you going, what works best for your business as to setting the highest standard, where we're going to give everybody the highest level of rights, the most strict, the most, or are there some business imperatives for only applying certain things, like the opt-out of sales share, Target, the digital advertising opt-out, on a more limited basis, because it really can affect some companies' bottom line. And then it's sort of like, all right, there's a lot here. And a lot of these laws are particularly California and Colorado, at least under their currently proposed regulations, have a lot of just in the weeds, overwhelmingly complex technical requirements, including notice requirements. So the whole idea of like notice being easily understandable so that it's transparent, that's out the window with these new rules. And it's just, you've got to explain things in one way for Colorado and another way for California, and you've got all these charts, and it's checking the box, and you got to do it. And that's the first thing you do, is like, okay, what's public facing? I got to have my notices up. They got to meet the regulatory requirements of what needs to be in the notice and formatted and using the enumerated terms and all of that nonsense. I need to get my cookie compliance in a way that meets the California AG's interpretation of sales share. And I've got to categorize my cookies, and I need to have the opt-out. Those are public facing things. I need to have a data subject access process, or as we call it in the US, consumer rights response process. And that needs to be working. And I got to at least, have the ability to provide, the things that are easily accessible. But the bigger issue, and what the heart of these laws is about overall information governance, about, as Brad said, really knowing what data do you have, where is it, How do I access it so that I can respond, so my notice is accurate, and so that I can actually respond to these requests? Most companies are not able to fully comply because they haven't integrated all their databases yet. That's usually step 2 in the maturity process. And honestly, step 1 is, I want to set the window dressing to make things, I don't want to be obviously out of compliance, right? So anything that someone can look at my website and say, oh, they're not doing this right, I better fix that. Step 2, if you're a legacy company that has, really complex data and hasn't really been doing a good job of mapping it or governing it, is mapping and governing it and getting rid of what you don't need. And California has, under CPRA, a retention program publication requirement. It's pretty meaningless because it has to be, your retention periods are based on category of PI. So for instance, name. Well, you're going to keep name for a million different retention periods depending upon the processing purpose, right? They should have said your retention program needs to be based on processing purpose, not data type. But the point is, even though the publication of the schedule is meaningless, the underlying requirements of data minimization and having a defendable retention and destruction program is what's really important there. And I think what we're going to see in the coming years is the regulators looking under the hood on that. And because everyone's saying, oh, I retain it for as long as I have a legitimate business purpose, or it's between, the time to conduct the transaction or 7 years, right? These periods are going to be meaningless, and the regulators are going to start looking behind it. And so getting ahead of that is sort of something that a startup company can do. But as Brad says, for a legacy company is step 2 or 3 on the maturity process.
Mm-hmm. Thank you so much. So what I understood so far, or summarizing it, is if you have a startup and you build a new business, start right away with some maybe privacy vendor helping you set up your whole system appropriately, that everything is clear, and you can also execute data subject access requests like delete my data, or what do you have about myself? Privacy Care is helping with that, for example. But otherwise, public-facing things first, so notice and policies, take care of people requesting their rights, or what data do we have, then cookies. And second, the whole data mapping, very important. And third, you should also really look into, do you have the right legal basis for the data you're processing? That's maybe the next step that is really important to. So Lisa, Microsoft, of course, is viewed as a leader in data privacy. How would you suggest a business owner responds to these new laws? I mean, I think Microsoft adapted many microservices and applications already that help companies using their products with compliance. But is there anything that you can recommend that companies can do, and share your experience on your from your side?
Sure. No, I think there've been excellent points made already in terms of it's really important to know what data you have and what you're doing with that. And I would just expand on that a little bit and say, it's really important to know what you do with your data and then say what you do. So, I think that process of understanding what data you have, where it is, where does it interact, also I think it's important to know where it came from, kind of the provenance of it, and to understand what vendors you're interacting and sharing data with and so forth, because you may need to understand what requirements that they have and how that may or may not impact you. So that seems like a simple thing when I say know what data you have and what you do with it. But boy, that's kind of the crux of the issue, right? From there, it's probably downhill in the terms of maybe simpler from there. But that's a big piece of it. I think also both Alan and Jasmine have highlighted kind of the benefit of a startup in the sense of starting from the beginning. So this idea of privacy engineering coming in from the beginning, and there are a number of startups that have popped up recently. We're going to see a lot more of those, I think, where they're building tools to help people privacy engineer from the very get-go. So we're doing that through development and so forth, and that will be very helpful. But companies that have more of the legacy data, or they've been operating for years, it's more complex for them. It's a different challenge. But I think know where the data is, what you're doing with it. What are the data flows in terms of the vendors that you're working with? What's the data life cycle? What are your policies? And I think it's a great time to go back and look at policies, in terms of retention and classification and things like that. And then there's an education process that I don't know that we've gotten to yet, but there's both educating your leaders in terms of making sure they understand your practices and what you're doing, but there's also training your team that's going to be dealing with this more in the front line.
Oh, yes, so very much. Thank you so much for this very important point. And also, as there is a lack of privacy professionals out there, actually, I mean, there might be a recession coming up, but privacy is blooming. So, and I can also point at the IPP here again. We have these huge conferences. We have like little knowledge net chapters. We have a couple of certifications in this space. So we are really a membership organization just trying to help privacy professionals. So please have a look at our website also in this regard. And also you touched on privacy tech, and maybe we can dive a little bit more into this. But before, I just want to mention that the IPP also has a tech vendor report, and privacy tech is also just exploding. So from like around 50 vendors a couple of years ago, I think we now have more than like almost 400 in our report. It's really so much going on in that space. Privacy engineering is in high demand, and it's really a field that is, yeah.
Well, and if I could put one more plug in there too,
Please.
for IPP, I think particularly and just the privacy field in general, diversity in the privacy sector is so much better than it is in a lot of the other tech sectors. Diversity is just great. So what a great way to, kind of tackle two problems at once in terms of bringing experts in and hiring professionals who are bringing diversity along with them. That's awesome. So yeah, there's going to be, I think, a lot of tooling and capabilities that we're going to see emerging because of some of the regulatory demands. We see that in other fields. When you see new regulations emerge, often we'll see new technologies, but it's an exciting time. But of course, I think all of us always feel a little unsettled when maybe some of the clarification isn't quite there yet. So I think as they write the rules to implement the law, I think that's going to help people to know what's expected of them as well.
Thank you so much. And Brad, I see you nodding. Is there something you could add in terms of clarifying how, I mean, let's put it that way. Are there any technical shortcuts to help smaller business owners become compliant? Or how can technical solutions help to scale privacy compliance programs, either in terms of state laws or more broadly? What do you see in this space?
Yeah, no, this is a really, really good point. I mean, I think, ultimately, if there could be a single source of truth, one place that you could go to manage all, doesn't really exactly exist. However, if you have an opportunity to have a solution or a platform that you can at least begin your level of communication that can then reach out or have hooks into other applications, and you could begin to move in that direction. If you're starting early days, it's easy to architect this. And to Lisa's point, if you're more of a legacy system, it becomes a lot more complex. So there are technology solutions that can work there. That's something that we're trying to do, or we are doing actually at Privacy Care, which is, pinning into APIs and finding companies like Jasmine, what are those solutions? What are those backend databases? Is it MailChimp? Is it HubSpot? What is she using so that we can give her a single pane and a single dashboard to be able to look at and use and leverage technology? Because at the end of the day, if people have to go and hunt all this stuff down, that just takes a lot of time, energy, and money. And Jasmine wants to sell her products, and I believe, and not necessarily, hire teams of people and legions of people to handle this. So we're trying to just make it as simple as possible.
Jasmine, now that we have you here and we have all those experts, tech, legal, big tech like expertise, Are there any questions that you would still like to ask people like this? Like as you have your platform, but what are your challenges still, and what questions would you like to ask this panel?
Yeah, I really see two challenges that at the moment, and this will evolve and get more complicated as I think you've observed already. One is around customer acquisition. You know, I some days feel like my hands are tied legally in terms of how I can retarget customers that are interested in what we do. It's becoming a lot more difficult honoring all the data privacy requirements that are out there, including, you know, Apple's iOS, where consumers themselves can pretty much tell you what you can and can't do. So my acquisition cost has gone up, and that does, you know, play heavy for a company who wants to have an exit at some point. So that's just a challenge, right? That I don't have a good answer for, other than we're playing by the rules, and it's just a lot more expensive, and it's just going to take a lot longer to acquire some of those customers. And the other challenge is, how do I control my, you know, the sort of the tangles of business connections, affiliate marketing, you know, as a consumer direct brand. You know, Amazon has our product and markets, and they have their own policies. Macy's has their own policies. And so, you know, I feel pretty good sitting here today, but it does worry me as these tangles just continue. You have more and more of them. You know, can I really control all of this?
And let me just interject there too, I think, because if you look at some of the back-end systems that you run your business on, so you mentioned you're on Shopify, and you might use, you know, MailChimp or HubSpot or, you know, something else. And, you know, a lot of people are under the misconception that those companies have privacy policies and solutions that will cover you. Most times they actually don't. But, you know, unless you go drill deep into their privacy policy, and lo and behold, you'll find that they say, no, it's actually not a responsibility. Nobody wants to touch it. It's kind of like a hot potato. Everybody's pointing at somebody else to say, no, not here. You do it. This other person's doing it. Oh, my cloud provider's doing it. So it's really beholden on you, you know, as the business owner to say, hey, who's doing it? We're stepping up and saying, we'll take it for you, make it easier for companies. And that way, you know, it is, you know, one solution that you can, you know, basically manage everything you need to manage, but it's challenging.
Well, and one of the other things that I don't, Alan may have a better perspective, or Brad, but Jasmine, I know you've talked about customers and consumers and how about reaching them and so forth. But I think one of the differences between CCPA and CPRA, if I understand correctly, is that they kind of removed the exception, or didn't include the exception for employees, if I'm not mistaken. So I don't know, Alan, can you speak to that in terms of, you know, the impact that may have?
Yeah, so CCPA, as it originally passed, defined consumers as California taxpayers. If your tax domicile, if you're an individual whose tax domicile is California, you're a consumer. But the law had limited application for the first 2 years on data subjects in an HR context, be they employees or beneficiaries, and business-to-business communications data subjects or contacts. That is since sunset. CPRA put a hard sunset on it. As such, it can't be extended unless it's done so in a way that is privacy enhancing, because a ballot initiative trumps anything that the legislature might want to do to change it. And the ballot initiative said amendments can only be privacy enhancing. So as of January 1, all those HR data subjects, all that B2B data subjects are in scope. That means cookies on a B2B website are in scope. And a lot of people are under the misimpression that it's a July 1 enforcement date, because CPRA cannot be enforced until July 1. So even though it became effective on January 1, you really have got, you know, an extra 6 months before an enforcement action can be brought against you. But CPRA, there's nothing to enforce related to employees or B2B subjects. It was already in CPA. and all CPRA did was put a hard date on the sunset. So the AG takes position, and this will probably be litigated, that HR and B2B data subject rights are fully enforceable today, that they need not wait until July 1 to bring an enforcement action. There's some ambiguity there, but that's something that people should be aware of.
Thank you. I mean, could you explain to us the difference between the Attorney General and the agency, the new agency?
Sure. So
Thank you.
Under the original CCPA, the AG's office was tasked with enforcement. The CPRA created a new agency, the California Privacy Protection Agency, that will take over rulemaking, or has taken over rulemaking, and will be a secondary enforcement agency, if not the primary enforcement agency. We'll see who has the bigger staff and the bigger budget, but they will both be able to enforce the CPRA come July.
Wow, that's gonna be a lot. And how is it like with you said California taxpayers? What if Jasmine has a so if Jasmine has a customer that is based in California, she needs to comply with CCPA and CPRA. Is that correct? What?
Right. So all the state laws apply on a data subject basis to their residents, right? And so and the common wisdom is it's your residence at the time you're trying to exercise the rights, not at the time the data was collected, although again, some ambiguity there. So if I live in Arizona, I've been a subscriber to a regional cable provider for years. I now moved to California. I exercise my rights, probably entitled to all of that data that was collected about me back when I was living in Arizona. Go the other way around. I moved to Arizona. The data may have been collected when I was in California, but I'm no longer a California taxpayer, so I don't have the right to ask for it anymore. Again, a lot of companies are saying we're not going to distinguish between states of residency. We're going to provide these rights to all of our customers. Others take it on a more discretionary basis. We will apply your state law to your request. However, we will entertain requests even if they're not required under your state law within our discretion. That's another approach. And again, some companies are segregating out based on territory. That's going to be harder and harder to do because, as you mentioned, Katharina, we're going to see a whole spat of new states coming online this year, and at a certain point, it'll just be like email marketing laws. There's going to be too much of a hodgepodge. One state is going to pass something, probably Washington or New York or Massachusetts, that's going to be so out there and different from what we currently have that the feds are going to have to come in and create a unified system, just like they had to do when California went overboard with email marketing regulation. And that's what got us canned spam as a national standard, preempting state laws with the exception of certain things like fraud and misrepresentation. So I think that we'll see this evolve into something that really will apply on a nationwide basis, even though in the short term, we've got the states are the great experimentation of democracy, right? The laws bubble up through the states, and then the best of breed generally ends up becoming the national standard, or at least that's the theory or the hope.
Mm-hmm.
Well, and I'll add to that Microsoft certainly has been asking for and desires a federal privacy law, and I don't think we're alone in that. I think there are a number of companies that have been doing much the same.
Yeah, it will be a relief for everyone if otherwise you have to comply with maybe even contradicting state laws, right? I mean, very complex. So I would like to encourage the audience, as we have this really fantastic panel, to ask any question that would be on top of your mind, or it can be a very complicated question or a very simple question, you can also, if that's possible, speak up as very small group. And yeah, we would be happy to answer any questions. I mean, I'm speaking for you here.
Feel free to jump right in and talk, or you can put your question into the chat window. If it's in the chat window, we'll be able to record it for you. And if there's something we can address on today's call, we're happy to do it. So don't be shy.
Yes, please, Enrique.
Thank you. Greetings from Mexico. I have a question here. I have a lot of clients that target Californian citizens for marketing purposes. I have advised several tourist industries here in Mexico. How would the CPRA will affect these campaigns that usually are done by Meta or Facebook? How would this translate into a practical risk for my customers that are here in Mexico?
So let me jump in on that one to start off, because one of the big fundamental changes of CPRA was to expand the opt-out from sale to share. And sale is broadly defined, doesn't require, at least in California, cash consideration. But basically, it's the making available of personal data in a context that either is not to your processor, who's limited in their processing activities to providing you services and nothing else other than some very limited exceptions like security and fraud prevention, or the disclosure is at the express direction of the user, and a few other little things like M&A transactions. And so that's how cookies got brought into this do not sell, right? Because the cookie, the theory that the AG has put forth is the website allows the cookie on the site, therefore it's making the data available. It's not an independent collection. If the cookie is not limiting its data processing to providing the services, which is the context of interest-based advertising, creating a pool across time and services, then it's a sale and has to be subject to the opt-out. However, Meta and other platforms were able to say for their custom audiences, we're not going to use your data. You give us a list of give us hashed emails of your 10 million consumers, and we'll create lookalike audiences to send targeted ads on our platform. That would not be subject to the opt-out under the old regime, under the CCPA regime, because they'd say, we won't use your email list for any purpose other than to provide you these services. Now there's this concept of share, do not share. And share means the making available the data in the context of processing for cross-contextual behavioral advertising. So now anytime you're going to take data from two places, from the brand and from the social media platform, in order to use it for advertising purposes, that's a share. So all this custom audience that was not subject to the opt-out before is, as of 11 days ago, now subject to the opt-out. So that's one of the big changes. Beyond that, there's some additional rights that start to look a little bit more GDPR-like. So that should be taken into consideration too. But for your travel clients, that extension of the opt-out to social media platform targeted marketing is a big deal. The other thing I would say is, California is the one state that doesn't have a state residency processing threshold, but rather has a worldwide revenue threshold. So any company with 25 million of worldwide revenue is under CPRA, regardless of the number of Californians whose data they process. And so we've got some multinationals with like one employee in California, but they're clearly over 25 million. So they got to have an HR privacy notice and consumer, that DSAR process for that one employee.
Thank you.
It would be me for the IPP. So thank you for this question from Enrique. And so Dennis has a question that there's some conversations about AI-based automated data discovery software systems, and is wondering if there are reliable tools available. I think this falls under transparency enhancing technology, like something like code scanning that was used for security purposes and now is used for PII. Is this what is meant by this question? And who would like to has experience with this kind of services?
I'll start with a little bit just to say I'm not sure which specific angle they want to go, but I think there are good technology systems out there that are able to scan data and detect anywhere from 70 to 80 different types of data, account numbers or social security numbers, birth dates, a lot of the the kind of structure there that we are familiar with, and can do that across multiple countries, and even the difference between a driver's license in one country and another country kind of thing. So I think the technologies there are there, and they're pretty good. In fact, I think in some cases they're very good. They can help. You can do the scanning manually, obviously, or you can do the scanning automated. And there's a lot of customization that you can build in terms of setting your own types of data that you're particularly looking for. I think one of the big things where people make mistakes often with bringing technology in, and bringing technology in is great. You're going to need it, especially if you're a company of any size. But one of I think the challenges is that sometimes everybody wants to settle on all of the decisions before you get started. And anytime you are getting into a situation where you want to start scanning data, my suggestion would be start scanning the data. Settle on the decisioning while you're scanning, because the scanning doesn't happen overnight. It can often take a long time. So start the process and do some of the decision making while the process is running. Otherwise, I think you're just kicking the can down the road, and you need all the time you can get at that point.
Thank you. And I just posted a post of mine where I tried to summarize what I see in the space. So maybe this is also interesting. And there's also a document summarizing what I would call transparency enhancing technologies, because they make the whole data mapping or whole tech stack more transparent. I also see a lot of
I'll also interject that also assumes that you have, as Alan's indicated, policy, governance, you have a foundation of what you're building on, right? And at least I don't disagree with, yes, begin scanning, but you need to be, having an end state in mind. And yes, begin for sure. And it might be real time as you're going to do it. And you're going to kind of, make sure you're moving in a direction, but it really has to start with a policy and know that you're going somewhere and you're doing something. So starting with a foundation and then selecting the right technologies that will be able to get you there. I think that's really the key.
Thank you. I actually think I asked Jasmine what the main challenges are, and then I somehow directed the conversation away from addressing those challenges. So maybe we could go back to that question or this challenge that you see about the customer acquisition and how I think retargeting, like is Ellen, Brad, Lisa, could you maybe share your ideas or experiences about those challenges? Yes,
just
please.
to clarify, I mean, it's two things, right? It's retargeting based on where they've been and what they've done otherwise in the internet. That's one. But the other challenge is, I have thousands of people who once got an email, opted in and then opted out. And I'd really like to market back to them, but I really shouldn't, right? Because they opted out. And so I struggle with, well, what do I do? How do I reacquire those customers? Because maybe they just accidentally opted out. I don't know, right? Because I'm not really talking to them, but I hate to lose anyone who's already been a customer from that. Our most effective tool, which is our email marketing, is really our top revenue converter tool.
So on that, Jasmine, what a lot of companies do is to provide some kind of incentive in order to opt in or opt back in to email marketing. Sign up for our newsletter, get 10% off your next purchase. loyalty programs, where you're going to get ongoing discounts and other benefits or points. Just a couple things to be aware of or to be cautious there. One is no problem if it's a previous canned spam, unsubscribe from email marketing. If, however, it is a do not sell share, you've got a 1-year limitation before you can solicit to override that opt-out. Shouldn't really be an impact on email marketing. Second is any kind of providing of a benefit or a price or service difference in connection with the collection, processing of personal data is in California deemed a quote financial incentive program. And that requires particular notice requirements, the ability to withdraw consent. And in some cases, if there's a price or service difference, a valuation statement that establishes that the value of the benefit given is reasonably related to the value of the data received. And there have been a bunch of enforcement actions on that. And then finally, if you have loyalty programs where you're accruing something, points, for instance, those should be constructed in a way that you don't create a cash equivalency or money value, which is people want to do that all the time. Say, for every dollar spent, you're going to get 10 cents back in credits. Well, now you've created a virtual currency. You've got anti-money laundering issues. You've got escheat issues. You're accruing a liability that when you go to sell the company, you've got all this accrued liability. And so the better thing to do is to set it up so it's a floating redemption that you can change the redemption, the accrual and redemption at any time. There's no cash value, no property interest. You start creating property interest and you're going to have people getting divorced, trying to get their spouses 50% of their frequent flyer points, et cetera. But the loyalty programs are great. Consumers love them, and they're more than willing to exchange their data and to be subject to marketing solicitations in order to, get something back. And that's value to the consumer. That's providing them value for their data.
That's great. Those are some great points. Thank you for that.
It's good that the session is recorded because the question was seemingly so simple and the answer was necessarily so complex. So that's privacy, right? Yeah, do we have more questions from the audience maybe? I think this is such a great opportunity to ask questions. We have a coaching situation here by some really insightful experts. And Enrique, do you want to ask something else?
Yeah, it's a question for Lisa, but it's not related really with privacy. It's more related with artificial intelligence chatbot GPT, if they are going to use it with Cortana.
I can't answer that one, so sorry.
I mean, I can pipe in a little bit about this. I mean, so for a couple things to unpack there. First of all, AI, we're going to see a lot more regulation. We'll see how the California agency applies the AI regs that they're empowered to promulgate. The other states, essentially, they're looking to see if there's a way where it's discriminatory, that it has a material impact on your legal or financial position. But the more simple stuff that doesn't have a material impact, like chatbots, for instance, or session replay, where you're capturing people's activity in order to improve the site functionality. The bottom feeders of the plaintiff's bar have sort of grabbed on to this as the new disability access claims under theories of wiretapping. And so there are thousands of cases being brought under state wiretapping laws regarding monitoring of the website, and on the chat, the transcribing, just like on the call centers where this call is recorded for quality assurance purposes and training purposes, blah, blah, blah. If you don't have something similar on the chat bot, prior to the time that someone starts the chat where they're acknowledging that it may be transcribed, including by vendors, you can expect a suit. Even more challenging are the session replay cases because there's no affirmative action. You'll see some sites, they'll do a pop-up that says, the site will be monitored for session improvement, opt out. That's pretty rare. Most people are just letting it happen in the background. And the big question there is, do you have implied consent through the privacy notice? Clear, conspicuous can be a challenge. But also, is it a third party or not? Is that vendor a third party? If they're not a third party, most of these state wiretapping laws are not going to be implicated. So are they truly an extension of you, essentially a tape recorder that you are using? And what that boils down to is, can the vendor do anything with that data for themselves or their other clients? If the answer is yes, they're a third party, and that's going to be a more challenging suit to defend.
Thank you so much. This was extremely insightful. Thank you so much. So we have 2 minutes left. How do we want to spend our last 2 minutes? We want to have a final round maybe, or Ashley, how would you like to wrap this up?
You bet. Thank you. Yeah. Let's. What's really fun to do on these sessions is at the very end is for each of the panelists to give their final 1-sentence advice on what to do next. We always like to have a closing action. So in this case, we'll get 4 closing, if not 5 closing actions. And then what I would also encourage all the attendees to do, write back, because we're always looking for the next topic. And I believe we're going to need to have more topics on privacy. So we'd love to set up separate sessions if that makes sense. Maybe even get some type of chat discussion going with parties that are more interested in next steps. So that's the 2 follow-ups. Let's go ahead and go around the horn and just ask every panelist their final 1-sentence closing statement.
Yes, please. Who would like to start? Fred?
Sure. First off, thank you all. This is really amazing to be able to hear everybody's thoughts and perspective. I would say in terms of, what you're going to do for consumer data privacy, and Lisa said it, very appropriately, which is you have to start. So begin somewhere, select a tool and begin. I mean, I think that's the most important thing. Take a simple approach to it. And then as Alan indicated with some of the legacy data, make sure you actually have a policy and have governance, and you're moving towards something. But that's the key, is just to begin and document everything you're doing. Critically important.
Thank you. Lisa, what would you add to that, or what would be your 2 cents or 10 cents? Or
I think my takeaway would be to think of this less as a burdening thing that you have to do, or a requirement that you have to meet, and think of it more as an opportunity to build trust with your customer. I think many of us, if you think of just one example, I think a lot of iPhone users would tell you that they value Apple because they feel like Apple protects their privacy. And so I think it's a great opportunity to build trust and, additional opportunity with your customers.
Great point. Thank you so much. Jasmine, would you like to?
Yeah, so for me as a business owner, I think the takeaway is every new tool or new platform that we look at bringing in to scale our business is to really have a look at the data privacy as well, and not just assume just because it's a plugin or blessed by Shopify that's an automatic, but really be proactive on that.
Very precious advice. Thank you. And Alan, what is your call to action for us?
Well, I mean, I'd say keep in mind that information governance is a journey. You're going to constantly be reassessing and maturing. But my one sort of takeaway would be, in order to be successful, you really need to have somebody in authority who takes responsibility, because there's a lot of stakeholders in a company. And without, a leader, even though it must be a collaborative process, there has to be somebody who's ultimately accountable has the authority and the mandate from the board and the C-suite to go out and get this done.
Thank you so very much. It was super insightful also for me, although I already work in privacy, and it was just a pure pleasure. Thank you so much for having me. Thank you to all of you joining and listening in and speaking. And I will pass over to you, Ashley, to say some.
Thank you. We did not get your final statement.
I'm in privacy engineering. I'm a total fan of privacy by design from the very beginning, and there's so many great new privacy tech approaches. So I'm a total fan of Jasmine's approach. And so right from the beginning, right from the start, go for it, because it will save you a lot of nerves and risk.
Excellent. Good. All right, folks. Thank you for everybody who attended. We appreciate your time with us today, and we are all available to talk to you more about this later. So until then, have a great rest of your week.
Thanks, everybody.
Bye, everyone. Thank you so much.
Thank you. Take care.